Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. She points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Hey, oh, folks. It is Sunday. It is 3 p.m. And I have had so much to do. So I haven't had time to update myself and you guys on what's going on with Laura Owens and David as Gingras. So, thought to myself, let's have a nap. Let's wake up. Let's decide. WrestleMania is not for another few hours. I have time to kill. So, well, let's kill it. No. Let's see. There you are. There you are. Ah! Let's see here. Let's do more like that. Hey. So, hello, you at Rumble. Hello, YouTube. Hello, X. Yeah, streaming this on X as well. I just don't get the... Oh, well, there are people over there as well. Hey. So, what we are going to do today, we are going to watch the latest hearing with Laura Owens. It is a complex case hearing, not especially long, but it still has information that is good to know, how things is moving forward, what she's trying to do, what the state is trying to do, and all of that. Then we are going to go into David Gingras' phone conference. That'll be fun. That would be the State Bar of Arizona versus Gingras. Now that will be audio only. And then we will finish off with David's affidavit. Yeah, he wrote another one. And it's 144 pages. I would assume most of it is repeating himself. But I mean, so we all can get, okay, here's where we are. And so that's the plans. That's the plans, at least. Let's see. Who do we have here? Hello, Doc Lotus. Hello, Philip Martin, aka the Cat Lady, Texas Packet, Denise Sells, Abe Linney. I'm not good at Irish names. It's probably pronounced not like that. We have Debbie, we had Elfie, we have Mimi's, LMP, damn Grangle, Gwendolyn Horse Welfare, and a bunch of more people. So good to have you here, folks. Good to have you here, folks. Now, before we go into that, Monday, I will do a collab with Megan Fox. It is another one of these cases where a hospital and a CPS worker stole a child. Now, that trial has already happened, but we got the videos, so we can see when it is the Hernandez family who is trying to get their child back, and the state, through the hospital and its CPS worker, is trying to steal it. So we get to see how it turned out. Now, before we go into, we will have Monday, I don't know the timing of it yet, but it's always great to know that this is one of the cases that turned out in favor for the family. But also, it is one of these cases that is really, really important, because when the state abuses its power, kidnapping children, they need to be held accountable. And it's an uphill battle because every state actor has some form of immunity. They give themselves immunity so they can kidnap children. So yeah, these medical kidnapping cases, I wish I could do all of them, but these cases are almost always under seal until after everything is done. Now, so we are lucky that we got a hold of this one. I know that Megan has been working on it for a long time. So do me a favor, folks. Go over to Megan Fox's channel, subscribe to her, look at her link stack. Look at my link stack, by the way. That way you can subscribe as well. So the entirety of next week will be about that case. And thank you to LO pulling out of BK. Hello, Victor. Thank you for your $2 super chat. Well, let's wait and see. Let's wait and see. So, now, are you ready? All right, folks. So, let's go right into it. Let's see. Hold on. I have to put you down here. Okay, that way you can see me as well and hear what's going on there. Okay, folks. Let's see what... and of course, as always, how is sound? How is sound? All right. Let's go. Let me... there. Let me just... the initial boost. All right. And thank you to Schnitzel Ninja on YouTube for
Which one do you
uploading
want to call
this.
first?
So, you see first.
All right, this is CR 2025-007905, State versus Laura Owens, time set for a complex case management conference. Can I get appearances, please? Mr. Cohen, can I get the state's appearance, please?
Which number, Your Honor?
Number 10.
Kevin O'Connell for Ed Leiter on behalf of the state.
Thank you.
Good morning, Your Honor. Christian Leaders on behalf of Laura Owens, who's present with me at the podium out of custody.
All right, good morning. Ms. Owens, can I get your name and date of birth, please?
Laura Owens, 5/14/1990.
All right, thank you. All right, I did get the complex case management report. Thank you for that. Mr. Lawyer, is there anything you wanted to talk about today that isn't encompassed in that pleading?
We did not talk about the motion to permit out-of-state travel that we filed last week in the CCMC report.
Yeah.
So Laura Owens again wants to travel out of state, this time to visit her sister. Now, we went through a bit about this on the Friday stream, my Slightly Buzz stream, on how Laura Owens, her bankruptcy case is dismissed with prejudice. She cannot file for a year another bankruptcy. Now, why does she all of a sudden have to go out of state? My guess, hiding assets. That would be because last year, her mom and dad Owens got their bankruptcy case dismissed, and because they refused to provide documents, now Laura Owens. And for me, it seems like this is tactics for them to move assets. That would be my guess, which also means that Laura's sister, knowingly or unknowingly, might make herself an accomplice. That is not good. So Laura's sister, if you happen to come across this stream out of curiosity, you have children. Those comes first. Or if you have one child, two child, I don't know how many kids you have. Don't get involved in Laura's crap. Don't get involved in your parents' crap. You are not helping. You are risking your children's future. Put your children first. For the love of everything, put your children before them.
I did receive that. State have a position.
Your Honor, the state takes no position on that particular request, and victims' rights have been complied with.
Okay, thank you. I'll go ahead and grant the motion. Ms. Owens be permitted to travel to San Diego, California between April 10th and April 17th, and then from May 28th to June 2nd. All other release conditions remain in effect. As far as...
Yeah, so 2 dates. Now, the first one, she's already been out of state, and the second one is in May. And of course she wants to travel and meet her sister. Well, I don't mind that at all. But under these circumstances, when her debt is just getting higher and higher, and I have no idea how she's paying for her criminal attorney, because apparently that guy is not court appointed. I have no idea how she got that money, because according to herself, she's been broke since the day she was born.
So we got dates in July. When do you want to come back for another complex case management conference?
So there is a plea deadline on the books right now for late in April. Mr. Leiter and I have talked about extending that just because the volume of discovery I'm still going through it. We're going to need a little bit more time, but I think that a mid-May date probably, and I'm looking at if Your Honor has room on his calendar the week of May 18th. I'd love to come back then. Realizing that Mr. Leiter hasn't actually given me an extension. I don't know if you had anything in the notes, Kevin, about that, but I think that week would be good to come back for a CCMC.
All right, can we accommodate that?
May 20th at 8:45.
How's May 20th at 8:45?
That works for defense. Thank you.
Is that good for the state?
Yes, Your Honor.
Yeah. What's going on here is something that we see all the time when I stream Judge Simpson. They're just there to meet up to give the judge updates. They have already filed the paperwork to get the judge up to date when it comes to handing over discovery. Is there a plea agreement? How and all of that. Now, the plea agreement here is I don't know what it is, what it contains, but there are 14 charges, and I would guess that the plea agreement is plea yourself, and we won't send you to jail. You pay a fine, you get probation, you get a no contact order, and off you fuck. Problem is Laura Owens, who I don't think is mentally capable of admitting she is doing wrong. And I've said this before, said this numerous times. Laura Owens, when she does what she does, it is because she feels entitled to do it because people are against her. She's not doing wrong in her mind.
Right. In the event you have trouble with the extending the plea deadline, we can get you on the calendar as needed if you need anything. All right, so Ms. Owens, you need back in my courtroom May 20th at 8:45 for a complex case management conference. Final trial management conference is July 22nd at 8:45, still in this courtroom. Trial assignment's July 29th at 9 o'clock before the trial assignment judge. Same building, 5th floor, courtroom 5B. If you fail to appear, warrants could issue for your arrest if you don't show up for trial, could occur in your absence. Got all that?
Yes.
Okay.
Thank you, Your Honor.
Thank you. We're in recess in this matter.
Thank you, Judge.
Yeah, so it's basically the same as last time, for us at least. So Laura wants to go away somewhere. The state doesn't mind. I wonder if they have a wiretap on her. I keep wondering, I wonder if they have a wiretap on her. And I wouldn't be surprised if they have. And so we have a few dates. Well, end of April is end of the plea agreement. Now the judge said something about maybe extension of the plea deadline of plea. I didn't hear the state saying, yeah, sure. But and then May 20th, they come back. June 22nd, they have their final conference, and then this goes to trial court. And yeah, it seems to be going along. This is very streamlined. I've seen trials that are much easier than this. That takes a lot longer to get to trial. Because something happens. But here it is very much, straightforward. And I don't mind. I would love to see this trial happen before the end of the year. I'm hoping. We don't know yet if it will be live. Please. But it's very, very streamlined. Considering they started raiding her home in January of last year. But yeah, again, I don't think Laura will take a plea deal. I think David Gingras is desperately trying to postpone everything that he is up for, including but not limited to his, well, he's fighting against disbarment. And for good reason. For very good reason. Because his credibility, if he testifies in her criminal trial, if he is banned from practicing law, that will be used to impeach him. That is why he is desperately trying to, his second DUI, why that is getting postponed all the time, and also his case against the Arizona State Bar. Why he desperately tries to postpone it with affidavits, with he's throwing everything against the wall. Everything. And I don't get it. Why would he ruin his career for Laura Owens? She can't. First of all, she can't be that good at whatever she does to keep David around. I mean, it's impossible. And I can't think of any woman in history that is worth your career. I really don't. But there are examples throughout history of powerful men meeting a woman who is absolutely unhinged, and all of a sudden everything goes down the shitter. So, yeah, I don't get it. I don't get it. All right, so that is more or less what I had about Laura Owens, because, well, she had a motion to allow virtual appearance on April 7th, but that was denied. That was before this hearing. That was before this hearing. And the court said, no, get your ass in here. Get your flat ass in here. Did he do something other than lawyering with her? His second DUI in the middle of the night, less than a mile from her home. I don't know. But it is suspicious. Yeah, good point. Depp fell for Amber, yeah. But then he found out she was a crazy person, and David has to know. He has to know. All right. Next up, David Gingras. This is audio only, and again, a huge thank you to Schnitzel Ninja on YouTube. Go subscribe to Schnitzel Ninja, who finds these and uploads it. All right.
Yeah.
Testing 1, 2, 3.
Alright, so we are on the record, and this is with regards to PDJ 2026-9010 in the matter of David S. Gingras. And before I take notices, I will note that we do have a public member who is connected in. They are the only public member that we have received a request to participate in this telephonic. However, of course, we would accommodate such because this is a open and public proceeding. However, I do want to highlight it is a proceeding. It is a status conference that this court, the PDJ set. And so I will just remind all folks that are present that Rule 122 does apply. So this matter is not to be recorded unless they have complied with Rule 122H if it's a personal recording. And if that were something that someone did comply with, then I would just remind the folks that are present in the record that there are certain prohibitions that are provided under K. Having said that, we have allowed the member of the public in, but this being a proceeding and you are not a party, you will not have the floor to speak or participate in any way in the proceedings. Having said that, if counsel for the State Bar can announce for our record.
James Lee, Senior Bar Counsel for the State Bar of Arizona. Present with me also Senior Bar Counsel Craig Henley.
Thank you. And then respondent.
Good afternoon, Your Honor. This is David Gingras.
Thank you. Okay, so Mr. Gingras has had filed a notice, and that's a notice State Bar's failure to comply with disclosure rules. That was filed on March 30th. The State Bar did file a request for clarification response requested or required, and that was filed on April 1st. The disciplinary clerk did then issue the order setting this telephonic, and it was set pursuant to the rule that respondent had identified in his motion, and that is Arizona Rule of Supreme Court 58F3, which does require that the court set a telephonic within 5 days. Having said that, I did review your notice, Mr. Gingras, and I'll start with you. I'm not sure that I see what it is that you think is missing from what you described the State Bar has provided you. So can you enlighten the record?
Sure, Your Honor. So the issue deals with disclosure of Judge Mata's testimony. The State Bar has disclosed Judge Mata as a witness. What they have not done is disclose anything regarding the substance of her testimony. With respect to their specific allegations in the complaint that I made false statements about Judge Mata. The initial disclosure from the bar, which is on page 2 of my notice, says absolutely zero, nothing of any substance at all regarding these alleged false statements. They're not even referenced, other than to say Judge Mata will testify about the adverse impact of my posts about her. That doesn't tell me anything that she's going to say about, are these posts true? Are they false? There's nothing about the substance of her testimony on that issue. I then met and conferred with Mr. Lee about this, and as you can see on page 3 of my notice, the bar supplemented their disclosures to add at least something, which I've referred to as essentially a fair denial, that Judge Mata will testify that she didn't do anything that I accused her of. But then there's a really shocking, almost a footnote at the end of that paragraph that says bar counsel is attempting to confirm whether Judge Mata will in fact testify as stated. And I've characterized that as essentially admitting that bar counsel violated Rule 11 by making extremely serious allegations of misconduct against me without even talking to the only witness who could testify to that issue. So where we are right now, Your Honor, is we are days away from the dispositive motion cutoff, and I have not a single clue what the bar's star witness is going to say against me. And that's a clear violation of the disclosure rules. I have asked in my notice that you find the violation is willful and that you simply preclude Judge Mata from testifying. But that's not actually what I want, Your Honor. If you were to do that, basically that gives me a win, but a technical win. And I don't want a technical win. I want the truth to come out. What I said about the judge was unfortunately true. And I've been accused of lying about that. And there are now hundreds of videos on YouTube because this is a high profile case and somebody released the complaint. I didn't do it, but, and I understand it's a public matter anyway, but.
Mr. Gingras, you post everything about this bar. Absolutely everything you have posted yourself. Everything. Now, disclosure here. This is a court proceeding. Yeah, it's the Arizona State Bar. I actually think that let's in this very, very specific case, I believe David has a point in he does not know what Judge Mada has testified. How is he supposed to prepare for that? Now, I don't think it will be anything shocking. I believe that Judge Mada more or less said, I did not say those things. I did not do those things. I believe it will be a very, very short testimony. But then again, why is it that in the state bar he can't know this? So, but that is the one thing out of every piece of garbage Mr. Gingras has posted that I actually agree with him on. Now, the way he argues it is horse shit. Absolute horse shit. His motion to compel is like chat GPT on acid. So it's hard for the state bar to also comply with the junk that he submits to them. So he kind of has himself to blame. Hello, Mr. Gingras. Hello. So he kind of has himself to blame, because here's the thing with screaming wolf 24/7, that the one time you actually have a point, nobody fucking cares and nobody listens. So he kind of have himself to blame for this one issue I actually agree with him on.
All of these false accusations the bar has made against me are out online as part of social media. I'm entitled to vindication, and the only way that we can do that is by having Judge Mata testify and explain what she did and didn't do. And right now, we don't have any disclosure from the bar regarding that testimony. So what I'd like the court to do is to order the bar to tell me and to tell the court whether or not, first of all, whether or not Mr. Lee or anyone else has ever spoken to Judge Mata about this case. And then number two, if the answer is yes, what did she say? I'm entitled to that information.
Well, I'm not sure that I embraced your argument. Having said that, let me turn to the state bar. And so, Counsel Lee, because I'm assuming you're the one who's going to take the lead in response. It does not matter to me if it's you or Mr. Henley. But the notice, as far as what Mr. Gingras has just described, as far as the state bars providing notice with regards to Judge Mata and the testimony the state bar expects to elicit. Is there anything that you disagree with regards to what Mr. Gingras has said or put in his notice?
Yes, it's State Bar's position that the disclosure, including the supplemental disclosure, sufficiently provides Mr. Gingras with sufficient information to investigate and prepare his defense. His request for the information provided by Judge Mata to the bar is, in the State Bar's opinion, work product, except to the extent to which she's going to testify. My experience has been that the court does not typically require opposing parties to disclose every statement that a witness is going to make while on the stand, but sufficient detailed and categories have been provided to Mr. Gingras in the supplemental disclosure statement. So we believe that that is sufficient.
Again, we are talking about this had this been a criminal case, if she had testified, if this had been any other witness, not a judge, then that testimony in its entirety would have been provided to the defense. But this is a state bar, which is a different kind of proceeding. Mr. Gingras. Yeah. And so I understand that there are different rules. And they did supplement, which means in general, this is what she's going to testify about. And it's not hard to figure out. She's going to respond to your bullshit, Mr. Gingras. That is what she's going to do. It's not hard to figure out. But yeah, I do believe in principle, even though it might be according to rules, according to this specific proceeding, I do believe that any defendant should know who and what he faces.
Well, I guess what I wanted to just make sure is, Mr. Gingras has injected certain portions of your pleadings in his notice. And so I wanted to just clarify, you're not suggesting that he omitted things that you think were controlling or relevant with regards to the question before the PDJ currently, right?
No, I believe, in fact, he has provided you with the entirety of the anticipated testimony that I included in the initial and supplemental disclosure statements.
And I will just note that with regards to the indication of bar counsel attempting to confer with Judge Mata, there are other pleadings that have been filed that does reflect that Judge Mata is being represented, and what those...
I'm very, very happy that this part of the screen is not live, because Mr. Gingras is currently having an only cats moment, and he's very, very thoroughly cleaning himself in ways that should not be visual to the public. Let's just say that. I mean, both legs widespread. Yeah. Yeah, you know what cats do.
Parties have, or that party had, or I guess just not a party, that on behalf of Judge Mata, whether or not there should be testimony with regards to Judge Mata, and that's something that's not yet before the PDJ. So I haven't made any rulings on that for today's purposes. Mr. Gingras, can I just ask you, when we started the initial case management conference, I noted Civil Rule 5.2 with regards to the requirement that documents be filed in black and white. And in the document that you've cited, your notice that's before me right now, you've used color. Some of your other pleadings, you have used color, and it appears cut and paste, as we kind of discussed at the ICMC, being really more appropriate for an attachment. Can you tell me what's happening, why you haven't complied with my directive?
Well, Your Honor, I printed my notice. I have it on my desk in front of me. The printed version is black and white. I don't recall if there's color in any of the screenshots that are included, but this is an unbelievably common practice that I've used for 20 years. I understand the rule requires text to be black and white, but what I'm giving the court are illustrations or essentially screenshots that are just used to help assist the reader in finding information more easily. If you don't want me to do that, I will do it the hard way, but I've just done it this way for 25 years, and I've seen bar counsel done it that way. I've seen courts do it this way. So I'm not trying to disregard the rule, and I certainly wouldn't disregard your order. If you don't want any screenshots and pleadings, you can say that, and I will comply with that. But I have the document in front of me. It's black and white in the printed version.
Well, you may have printed it in black and white. I have a color version, and I will direct you to where it's in color in your filing, and it's on page 3. I kind of referenced it as being something that you were highlighting. The statement bar counsel is attempting to confer whether Judge Mata will, in fact, testify as stated. That is...
Oh, yeah.
So
Yeah, I guess it's highlighting there, yeah.
I'm not sure where the confusion is from our first conversation. That's the only reason I'm highlighting this. And so I'm not doing something other than enforcing the rules that exist. And so
Yeah. Some of the most rigid, unreasonable things you hear of is when in regard of court filings. Courts generally have this, only black and white. And not only that, the font, the size of the font, and in some cases over here, what do you call it? The formatting. For the general population, why? For us who works with it, we don't know why. It's just the way they do it.
Civil Rule 5.2 indicates that in a document that it is to be in black and white. It specifically carves out the exception of exhibits or attachments. And so I'm not telling you can't use screenshots. I'm telling you need to comply with the rule if you want to present something that has color, for example, or has alternate fonts that are discouraged in Rule 5.2. But having said that, I've considered your request. I don't find that the State Bar has violated the discovery rules here or disclosure rules. And so your motion or your notice at this point, the PDJ is not going to take any type of remedial action because I don't find that the State Bar has done anything out of compliance with standard practice in disciplinary matters or pursuant to the rules. With that, we will stand in recess. Thank you all.
Your Honor, thank you. I'm sorry.
Yes?
Your Honor, there are other issues we haven't discussed.
With regards to what was set for today?
Yes.
What else was set?
So the Judge Mata part was only one issue that I raised in the notice. The second issue, which is on pages, let me see here.
Mr. Gingras, what I asked you to do was to enlighten me if there was something in addition. And so you got to go first, and I asked the State Bar, did they have anything else? So I'm going to give you back the floor, but at this point, I will just reiterate my first query to you. So I have your notice. Is there something else that you wanted to address with regards to the notice that was set for today? Go ahead.
Yes, Your Honor. I didn't realize that you wanted me to address every single issue at one shot. I raised.
If she wanted it any other way, she would have told you, Mr. Gingras. If she asks, address your notice, then you address the entirety of it. Don't assume anything when it comes to judges. If they say, address your notice, they are meaning all of it. Yeah, for the general population, I would rather have it point by point. Yeah, welcome to law.
The Judge Mata issue first because I wanted to talk about it first. On page 7 of my notice, it says, in addition to this issue, meaning the Judge Mata issue, a second matter has arisen which requires immediate resolution by the PDJ. And then I'm explaining here that Mr. Lee is acting as bar counsel, but he's also the complainant with respect to multiple issues in the complaint. He's the sole complainant. And I've tried to speak to him about his allegations, and he's refusing to talk to me. So there's been no disclosure from the bar with respect to Mr. Lee's testimony, and in fact, he's obstructing my ability to investigate what he has accused me of, and no one else other than him has made those allegations.
When you say Mr. Lee, are you talking about Senior Bar Counsel Lee?
Yes.
Okay. Well, so I will just tell you it's the State Bar that's the complainant, not Mr. Lee. He works for the State Bar. So anything else?
So, Your Honor, so if I'm not able to investigate the allegations, I understand that Mr. Lee works for the bar. He is the person that I've been speaking with for the last 18 months. He is the one that has corresponded with me. I've responded to him. And based on our discussions, Mr. Lee is the person on behalf of the state bar. But he is the one that has set forth allegations in the complaint that no one other than him has raised. So I need to talk to somebody.
You idiot. No, the state bar has gotten information to them and has decided these are the allegations. Mr. Lee is the representative of the state bar. So he has made 0 allegations. The state bar, through Mr. Lee, are filing these charges. It's not hard. It really isn't. Just as in a criminal case, you have the representative of the state, the prosecutor John Smith, just to say a name. That doesn't mean he personally is bringing charges. No, it is the state.
To try to ask questions about what are you claiming exactly. And I guess I understand it's the bar, but Mr. Lee is the person at the bar who has this information. So if you're telling me that I'm not allowed to speak to Mr. Lee, that I can't present a defense, that's fine. You can take that position. Obviously, I'll seek relief from that.
I think you've mischaracterized even your own pleading. You're saying you just want to talk to Mr. Lee, counsel for the bar, but you've described him in your pleading as a witness. And what I'm clarifying for you, Mr. Gingras, is the idea that Mr. Lee is a witness is incorrect. So saying that you have a right to communicate with him as a witness in your proceeding is incorrect.
Yeah.
Well,
He is the counterpart. He's not a witness. He's the counterpart. Just like in civil cases and criminal cases, you have a counterpart. In this case, the prosecutor is not a witness. In civil cases, opposing party counsel is not a witness. They are representing. It really isn't hard. It's kind of the foundation of Western law and has been so for hundreds of years.
I'll ask Counsel Lee to clarify. Have you taken the position that as far as in preparation for this proceeding, as counsel for the bar, you aren't going to communicate with Mr. Gingras?
No, not in a general sense. He asked me specific questions, which, because I'm not a witness and I am only representing the state bar, I refused its work product information that he's seeking in the state bar's opinion. So I refused to answer some of the questions that he posed to me.
All right, Mr. Gingras, what else?
Apparently nothing, Your Honor.
Okay, and so that I don't run afoul of this the second time, and I'm assuming that the state bar doesn't have anything else that you need to put on the record before we disconnect.
No, we have nothing further, Your Honor.
All right, well, thank you, gentlemen. We will stand in recess.
Thank you.
How can you have worked as an attorney for 25 years? He's been accepted to the Arizona bar since 2004, so 22 years later, and he does not know the concept of representation. Oh, hello, Dennis. Denise, it's been alleged that Gingras is going to have a lawyer representing him, but we haven't seen. That's being reported who is representing him. But I don't know. If once they get to the trial part, the State Bar versus David Gingras, I would say it's too late to have representation, because he's made so many filings in pro se filings in this, that how is anybody supposed to take that case? Unless he does a last minute hiring of an attorney and just to postpone it more. But again, I do believe that David Gingras, everything with his DUI case and the State Bar is about postponing until at least after Laura Owens have been after the Laura Owens trial, because it's about credibility as a witness, and he will be a witness in the criminal trial. He's lucky he's not a co-defendant. Let's just say that. He might be, but as of now, he's just a witness. I do believe the state intends to call him as a witness in the trial, because he represented some really, really disturbing stuff to the courts. Things that could not have been true. That he knows is not true. So yeah. But as long as he's not sanctioned, as long as it's only an ongoing investigation, he can claim credibility to the jury. So I do believe that is it. But, folks, as always, you would assume that he would, a normally functioning person, would have stayed silent until the next scheduled hearing. Not Mr. Gingras. Mr. Gingras files a 144-page affidavit and I assume it's going to be the same horse shit as always, but let's go through it and see if there's something new here. I doubt it, but let's see here. I, David S. Gingras, hereby swear and affirm under the penalty of perjury as follows. His name is David S. Gingras. He is a U.S. citizen, resident of the state of Arizona, and over the age of 18. Mentally, and if called to testify in court or other proceeding, I could and would give the following testimony, which is based upon my own personal knowledge. I am an attorney licensed to practice law in the state of Arizona since 2004 and California since 2002. I am an active member in good standing with the state bars of Arizona and California. Yeah, correct. They haven't sanctioned him yet. So currently, he's in good standing. And I am admitted to practice and in good standing with the U.S. Court of Appeals for the 6th, 9th, and 10th Circuit, the U.S. District Court for the District of Arizona, and the United States District Courts for the Northern, Central, and Eastern Districts of California. On July 8th, 2024, I filed an affidavit in Owens v. Eckert in which I described the basis for allegations of misconduct I made against trial judge Julie A. Mara. Yeah, that's the one when he says the in quote, look at me, daddy, I'm a real judge now, tee-hee, end quote. That affidavit was submitted to this court as Exhibit 105 to my request for judicial notice. The affidavit is also available online here. Yeah, I think we already read it a number of weeks ago. At the time I submitted that affidavit in July 2024, every statement in it was true and correct to the best of my knowledge. No. You quoted the judge as saying certain words. No. That alone makes this a false statement. In several places. Today, I reviewed my July 8th, 2024 affidavit and can confirm once again that everything in the affidavit remains true with only the following updates. In several places, I described the number of followers of certain social media accounts and the number of posts made by some of those accounts and by me regarding the Owens v. Eckert case. All of the numbers in my affidavit were accurate at the time. In nearly 2 years that have passed since, the number of post social media followers has increased significantly. Streisand effect. In paragraph 67 of the affidavit, I provided a link to a YouTube page where a video could be viewed showing several people making allegations concerning Judge Mata and her father. That link is no longer working, but the same content is available on my website here. Nobody cares. This is not an update. This was in your prior filings, not an update. This is repeating stuff. I incorporate all of the statements in my July 8th, 2024 affidavit by reference here, and I'll reaffirm the accuracy of those statements in all respects, except as noted above. On March 18th, 2026, I submitted a declaration in this matter, which is available here. Yeah, but this is nothing new. So we're on point 7, and absolutely nothing is new. And then it claims everything in my March 18th, 2026 declaration was true and correct to the best of my knowledge at the time I executed the declaration, and those facts remain accurate today. I also incorporate all facts in that declaration by reference here. I'm submitting this affidavit in support of my motion to dismiss motion for summary judgment in this matter. Rather than repeating all of the factual history of Owens v. Eckert, which is exceptionally complicated, no it isn't. She lied. She got caught. You helped her lie, and you got caught. It's not difficult at all. I will only address those facts which are relevant to the issues raised in my motion. Facts relevant to Claim 1, violation of a court order. I am aware the complaint in this case accuses me of violating a court order by publishing information the court had ordered to be sealed or otherwise protected. That claim is 100% false as a matter of fact. I did not violate any order at any time. We know this is a lie. The order was there, and then Mr. Gingras filed documents to the court which included medical information. It really is that easy. Immediately after Miss Owens retained me, one of the first things I did was to ask her whether the court had issued a protective order. Doesn't matter. You have the court docket. You have everything available to you. You can read all the orders. And here's the thing, Mr. Gingras. You are fucking obligated to do it. You are not she told me, fuck off. Check the docket. You've done it before. Check the docket. That is your obligation as an attorney to be updated on the case before you start filing shit. Her response was, no, I asked for a protective order multiple times, but the judge denied every one of those requests. So, Mr. Gingras, are you disclosing attorney-client privilege information here? You're not a smart lawyer. You are willingly disclosing attorney-client privilege communications. Which is completely in line of his other imbecile things. After Ms. Owens told me the court denied multiple requests for a protective order, I reviewed the docket and confirmed her statements were accurate. I found Ms. Owens made 3 separate requests for confidentiality sealing order, all of which were denied in full. Well, apparently, you missed shit. And here is the thing. I found Ms. Owens made 3 separate requests for confidentiality sealing orders, all of which was denied in full. Those are not the only things that are submitted. As I discussed in more detail in my March 18th declaration filed in this case, I also noted that in his pleadings, Mr. Woodnick angrily opposed Ms. Owens' second request for a protective order, arguing any order prohibiting the parties from making public statements about the case or sharing information obtained during the case would be unconstitutional. Has 0 bearing on medical records. 0. In my March declaration, I included various quotes from Mr. Woodnick's brief opposing Ms. Owens' request for sealing confidentiality. Those quotes from Mr. Woodnick's argument are worth repeating. None of them matters. None of these quotes matters if there is a court order. None of it. This is bullshit. But he said... Doesn't matter. Does not matter one single bit. Hey, and look at that. And thank you to Derek for £2 super sticker. Video game controller gives a thumbs up and says good game. Yay! Thank you so much. Thank you. And then, so I don't care about anything here. Nothing. This is just your word salad. Again, Mr. Woodnick's final statement to the court was clear and unequivocal. There's nothing to be designated confidential. Except that Judge Mata issued an order that no medical records, all the medical records, shall be sealed. All of them. All of them. I've been practicing law for around 25 years. During that time, I've personally litigated hundreds of First Amendment cases in both state and federal court. Nobody cares. Based on that experience, I know courts typically can issue lawful orders preventing parties from disclosing certain types of information obtained in discovery. Medical records are almost always regarded as confidential. It's not typically can. Almost always, medical records are confidential. Not to be disclosed to the public. Under seal. For example, in my experience, it is common for courts to issue protective orders limiting the disclosure of certain types of information such as financial records, proprietary trade secret information, and personal medical records of the opposing party. Although courts routinely order a party not to disclose private, confidential information they received from opposing party, in 25 years of experience, I've never seen a judge order a party not to publicly disclose their own records or similar information. Bullshit. Horseshit, bullshit. And the reason why you might not have seen it is because a lawyer with a normally functioning brain does not want their client's medical records out in the open. So, why the fuck did you do it? I'm also extremely familiar with the circumstances under which courts can allow or order information to be filed under seal. Based on that experience, I know sealing orders are extremely technical and complicated. No, it's a fucking order. And they involve numerous procedural requirements to ensure absolute clarity for the lawyers and litigants. No, the judge says, I order this to be sealed. And then you work out the technical issues. But the order is always on top of it. Attached as Exhibit A is a copy of my third supplemented disclosure statement submitted in this matter. As I explained in this statement, in my practice as a civil litigator, I have often dealt with both protective orders and sealing orders, so I'm very familiar with the standards for both. Nobody fucking cares. You fucked up. You fucked up. That's the entire... What you should have done was to on your knees... Please, I made a mistake. But what you're doing now made it worse instead. Based on my knowledge, experience, and training as a civil litigator with decades of experience, I know exactly what a protective order looks like, and I know what a sealing order looks like. In Owens v. Eckert, the trial court never at any time issued either a protective order or a sealing order. I believe that is an outright lie. Outright lie. I'm aware on February 21st, 2024, Judge Mara issued a lengthy minute entry ruling which resolved multiple issues. In that document, Judge Mara issued several orders, including an order denying Ms. Owens' counsel request for reconsideration regarding confidentiality. In that same ruling, Judge Mara included an observational comment stating that the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. There it is. There it fucking is. There it is. No party shall disclose outside of themselves any medical or other documentation disclosed between the parties. There it is. Ta fucking da, asshole. It's right there. So, for the first 22 paragraphs, you are whining like a little bitch, and then, I found it. Listen to this bullshit here. My understanding of that language, based on discussions with Miss Owens is not a lawyer. You are. If you're uncertain, ask the court. Miss Owens knows jack shit about legal proceedings. Is blah 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 review of the file as a whole is this. Although Judge Mara denied Ms. Owens multiple requests for confidentiality, she nevertheless did not want Mr. Eckert's counsel abusing those rulings by gratuitously sharing Ms. Owens' medical records on social media. You fucktard! You absolute moron! In quote, let the record further reflect that no party, both of them, shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc. disclosed between the parties. It's right fucking there, you imbecile. Imbecile. Are you getting ads? I don't have that function on. I never have that function on my live streams. Now on for Replay Crew, I have one ad every 20 minutes or so. But if you're here, now, YouTube has this that sometimes in the chat section and beneath and stuff, they show ads. But you shouldn't see ads like here. So I hope, yeah. So when Gingras says here, he thought, oh, that means Mr. Eckert can't show anything. No. No party shall disclose. No party. You. Idiot. Ah, just the ads that cover up the chat. Yeah, I know those are annoying as fuck. The conclusion was based on the fact that Mr. Eckert never disclosed any medical records at all, so the comment about the parties not disclosing outside of themselves any medical or other documentation disclosed between the parties could only have meant as a restriction on Mr. Woodlick's ability to share information he obtained from Ms. Owens. No! No party shall disclose. None of you. None of you. None of you. Alternatively, let the record reflect, may have documented some sort of agreement made between Miss Owens' prior counsel and Mr. Woodlick. No. No. That's not even close to a correct interpretation. I do not know if that was the case because Mr. Woodlick refused to discuss the matter with me, and Miss Owens' prior counsel, Corey Keith, was also not helpful after I was retained. It's right there on the fucking docket. No party shall disclose. None of you. The order is crisp and fucking clear. Despite the language saying no party shall disclose outside of themselves any medical or other documentation, the document, which never said it is ordered, said nothing about sealing records or requiring pleadings to be filed under seal. No party shall disclose. It's not hard. Now he's just trying to split hairs. Oh, because if he actually believed this, I don't think he actually believes this. He's just splitting hair. Let's see. I'm aware there's a specific rule that deals with this exact issue, Family Law Rule 12, entitled Sealing, Redacting, and Unsealing Court Records. Rule 17 allows material to be filed under seal, but the rule contains multiple mandatory prerequisites. First, the court must make written finding of fact and conclusion that the specific sealing or redaction is justified. Second, the court must find there exists an overriding interest that overcomes the right of public access to the record. Did you check it? If the order is there and you have questions, you don't turn to Miss Owens, you turn to the court. Can I? What does this mean? You did none of it. Well, here's what I assume. Which I can, because I'm just commenting here on the internets. You didn't care. All of what we are seeing over here is an afterthought. He fucked up, and now he's trying to get himself out of it. The February 21st, 2024 minute entry contained none of the findings required by Family Law Rule 17. For that reason, I do not believe the court required or even allowed any information to be filed under seal. Let the record where is it? Here. Let the record further reflect that no party shall disclose. That is the order. If you have issues with the order, you know what you're supposed to do? You file with the court. I want to disclose this. And you didn't. In addition, shortly after I was retained, I learned that after the February 21st minute entry ruling was issued, Mr. Woodnick filed unsealed pleadings to which he attached medical or other documentation exchanged between the parties. Even if he did. This might have been a witness, an exhibit regarding a sonogram, the Fiverr sonogram, for example. That is not Miss Owens' medical records. That is an exhibit from another source. Was this a criminal trial? Family law, so not really criminal trial. It was a paternal issue between Laura Owens and Clayton Eckert, which resulted in Laura Owens has never been pregnant, so no, Mr. Eckert cannot have been the father of kids who never existed. Specifically, a few weeks after the February 21st ruling was issued, on March 11th, Mr. Woodnick filed an unsealed pleading, a motion to compel containing medical or other documentation exchanged between the parties. Let's see here. Yeah, it's the... Let's see here. Oh, oh, you idiot. It's these. These are not medical records. These are absence of medical records. These are, no, you idiot. You fucking retard. These are not medical records. These are exhibits showing there were no medical records. Oh, for fuck's sake. No. Paragraph 49 of the amended complaint claims that on April 4th, Mr. Woodnick sent me an email in which he stated, I'm also not certain why you are publishing court documents and your client's personal medical records contrary to court order. That allegation is true. Mr. Woodnick did say that in an email. However, the complaint fails to explain what happened next. Immediately after I received Mr. Woodnick's email, I sent him a lengthy response. Mr. Woodnick's email was sent at 12:56 p.m. and I replied to him at 1:30 p.m., literally 34 minutes later. In my email, I responded to Mr. Woodnick's comment about publishing court documents and your client's personal medical records contrary to court order as follows. Yada, yada, yada. Yeah, we have gone through these. Mr. Woodnick never responded to my statement. Mr. Woodnick never responded to my statement. If you interpret the order to mean that Laura is somehow enjoined from publishing her own record, you need to let me know that immediately so I can take the issue up with the judge. You fucking moron. Again, your responsibility is not... Rudnick has no responsibilities whatsoever to teach you, Mr. Gingras, about what orders have been submitted. He made you aware. Then it is your fucking obligation. File with the court. Hey, I might have fucked up. Does this minute entry, this order, does this mean this? Does this means I fucked up? If I did, my deepest apologies. But no, he tries to blame Rudnick. I interpreted the lack of response from Mr. Rudnick as an admission from him that my view was correct. Mr. Rudnick is not the judge. He made you aware, which honestly he didn't have to. At all. Because it's your fucking obligation, Mr. Gingras. And if you have questions, you take it up with the court. And why? Because it's your fucking job to do it. So, that the court had not issued any order that limited Laura's ability. No. Rudnick doesn't have that responsibility towards you at all. And then you claim, because Mr. Rudnick appeared to agree with my interpretation of the order. No, he didn't. Absence of answer is not an agreement to your statement. Never is. A no reply is just a no reply. Your responsibilities are towards your client to obey the rules of the court. It's not hard. What Mr. Gingras here is saying that, well, Judge Mara said, Mommy said I couldn't, but since I asked Daddy and he didn't reply, I could. That's what he's saying. It's a 5-year-old wanting a cookie, got a no from Mom, and Dad said nothing. Well, if he said nothing, then I can have a cookie. That's basically his argument here. No, because the court, if the court says no, it's a fucking no. If Mr. Rudnick believed that I had in fact violated the court order, he could and should have raised that issue directly with Judge Mara. He never did so. He doesn't have to. He just watched you making a complete ass of yourself. And okay, I can use this. Let him bury himself. And you did. We are on page 10 out of 144. I understand the bar accuses me of engaging in misconduct involving witness intimidation related to a person named Michael Maricini. That allegation is patently false. We went through this so many times. So many times. Mike was subpoenaed to the court. It was a lawful subpoena. The judge explained it's a lawful subpoena. And you tried to have him arrested. You tried to threaten him. Well, not try to. You did threaten him. And you failed. So nobody cares that you keep saying it was an unlawful subpoena when the judge already told you. It's a lawful subpoena. Sit down. Shut the fuck up. And then he goes through, blah, yada, yada, yada. And Miss Pollock said, Gingras, my client, will not be testifying. It's not her call. And even if he won't be, he's still subpoenaed. It's a lawful subpoena. regardless if he plans to testify or not. Yeah, and when he kept badgering Miss Pollock, she told him to fuck off. So, all of this, yada, 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 completely useless. Completely useless. Because, as Judge Mara said, it's a lawful subpoena. And Mr. Maraccini, if he's called to testify and he somehow says, I really don't want to, it's his choice up until that moment. Up until that moment, it's his call. And the subpoena is lawful. And you had that explained to you numerous times. So, yeah, I'm skipping this because this is just pure assholery from Mr. Gingras. Facts relevant to claim 3 assholes. I'm aware of the amended complaint accusing me of sending a private email in which I referred to certain anonymous individuals as total fucking assholes and total fucking psychotic assholes. I'm an asshole. Those words are accurate. I used them in a private email I sent to a website called Reddit. The purpose of that email was to notify Reddit that one of Mr. Eckert's supporters was infringing my copyrighted material by taking videos I was posting on YouTube and creating derivative works, which she then posted on Reddit in violation of 17 USC 106. Fair use, motherfucker. Now, I won't show any of his videos because I don't want false copyright claims against me. Because even if he loses, which he by all accounts will, that video will still be down for up to 30 days. And I can't be bothered. Not when I have stuff like this. The email mentioned the fact that I'm a lawyer, and I briefly described Owens v. Eckert to offer some context for the request I was making. However, the sole purpose of the email was to enforce my own legal rights under the Copyright Act. I was not acting on behalf of any client. I was acting solely for myself. As such, I was not engaged in the practice of law. If you send an email asking to have stuff removed and you are a lawyer, you are acting as your own lawyer. That is engaging in the practice of law. There's no way around it. Once you're a lawyer and you make lawful demands or demands of in this case under a Copyright Act, you are engaging as a lawyer. As a general rule, I always try to be polite and professional in my dealing with others. No, you don't. However, under appropriate circumstances, I may use colorful language if I believe it's necessary. In this instance, the language I used was entirely necessary. I curse a lot, which you might have noticed. So I don't really care. Also, as a lawyer, I'm aware that other attorneys sometimes use similar language for effect. Yada, yada, yada. Facts relevant to claim 4, meritless claims, false evidence, changing story. I'm aware of the complaint. The bar accuses me of a variety of misconduct which can be generally summarized as falling into one or more of these categories. Knowingly offering false testimony from Miss Owens to the court. Yeah. Negligently offering false statements from Miss Owens by failing to diligently verify her story. Yeah, that's your fucking obligation. Failing to address false or inconsistent testimony offered by Miss Owens. Yeah. With respect to the claim that I knowingly offered false testimony from Ms. Owens, this is 100% categorically untrue. In a hearing in October of 2023, she claimed she was 100% pregnant. Then you, under your guidance, she testified she had miscarriage months earlier. Yeah. You can't get... It's on the record, asshole. It's on the record. And he claims, I did not knowingly offer any false testimony at any time. That allegation is blatantly false and defamatory. When I first appeared in Owens v. Eckert in late March 2024, the case had been pending for nearly 8 months and the paternity aspect was effectively over. Nobody cares. When I appeared in the case, Ms. Owens was no longer pregnant and was not claiming to be pregnant. Therefore, her paternity petition was moot. She still lied. She lied. And you elicit that lie to the court. Blah, 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 blah. There's nothing new here. Everything he posts here has been... Everything here, everything so far is... Everything he has posted before to the bar. There's nothing new here. There's no... You filed... How many affidavit has he filed so far? 5? 6? Nothing here is new. He's just repeating himself. Yeah, I can't be bothered. I really can't be bothered. Folks. As I said about an hour ago, the sole purpose of all of this is to postpone things. Because he has to postpone his DUI case and the state bar thing. Because if he enters the witness stand in the Laura Owens criminal trial as a sanctioned attorney, then what he is sanctioned for, he can be impeached on. So I do believe, I mean, in that regard, he does not have much choice. Because he made the fatal choice 2 years ago to represent Laura Owens and to represent her and help her lie. And now it's coming back to bite him. Now, there's a different... Now, you should always zealously defend your client. Always. But you can't step over the line and elicit false evidence, false testimony. You can't attack the judge just because you didn't get your way. Because now all of it comes back to bite him. All of it. And why? For Laura fucking Owens. A serial pregnancy scammer who has been abusing men for over a decade. You're ruining every part of your career for a woman who does nothing but abuse men. David, is it really worth it? Now it's too late, because you have filed this garbage. You have done all these things. But at the end of it, once you're sanctioned, was it worth it? Can he claim attorney-client privilege if he's called to testify in Laura's criminal trial? He can claim it. But in my personal opinion, he's fucked. In this, he quotes discussions between him and her. Let's see, where is it? And this is here. Immediately after Miss Owens retained me, one of the first things I did was ask her whether the court had issued a protective order. Her response was, boom. He quotes her. That's privileged information. That is attorney-client privileged communications. And he discloses it. So even if he makes that argument, because he's done this a lot, quoting Laura Owens in his filings, it would be very easy for a court to determine, no, you disclosed attorney-client privilege information. Now, here's the thing. The only one who actually can waive this is Laura Owens, which puts Mr. Gingras in a very, very peculiar situation, because if Laura Owens is convicted due to the testimony that might be elicit from Mr. Gingras, due to the court saying, no, this is now waived, she can go after you. Laura Owens can go after Mr. Gingras. And I've said this before. Laura Owens' only defense in this criminal proceeding is to throw David Gingras under the bus. Because until he entered the picture as her attorney in the paternity case against Mr. Eckert, she had still not contradicted herself. She had still not filed things that were clearly lies. All of that was on Mr. Gingras. And how do I say this as gently as possible? The person who, when all of this is said and done, will have the most severe punishment is David S. Gingras. Even if he only is sanctioned for 6 months and a day. Yeah, but that's only for the things in these proceedings. In these proceedings, his second DUI is not included. The moment that has an entry of judgment, it's going to the state bar as well. So, if Laura Owens throws Gingras under the bus, pleads out for probation and a fine, she basically walks. Her life will be changed. But under the circumstances, that's quite light. David Gingras, might be the one person who comes out of this absolutely fucked. Oh, thank you, Dave. Rule 1.6, confidentiality of information. Thank you, Dave. Oh. Let's read this. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. A lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to prevent reasonably certain death or substantial bodily harm, to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest of property of another, and in furtherance of which the client has used or is using the lawyer's services, to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, blah, 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 to secure legal advice about the lawyer's compliance with his rules, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client, to establish a defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. Okay, so here, do I interpret this correct that David Gingras can make this disclosure in a controversy between the lawyer and the client? But there's no controversy between the lawyer and the client as of now. To establish a defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. Yeah. Okay, there it is. This is that one that gets David off the hook, Dave says. Yeah, okay. Maybe, but he hasn't argued this in any of his filings. So to my knowledge, he hasn't filed to comply with the other law or a court order, or to detect and resolve conflicts of interest arising from the lawyer's change of employment. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. So yeah, so this, yeah. Dave says, yes, you can make the disclosure if it's relevant to any disciplinary action against him in connection with this representation of the client, but only that which directly impacts this disciplinary action. I guess that is. But here is what bugs me with this part here. Let's show this. He's quoting her, but he is in this case, he's representing her in court, and he's asking her, which he can, but he still has to check it with the court, double check it, triple check it. And what is damning against him here is that he blames opposing counsel when all he had to do was to check with the judge. Yeah, he has to be really careful to only reveal stuff that directly relates to the discipline. Yeah. But I don't think, because how it then continues by blaming opposing party instead of actually checking with the court. So I do think he's kind of screwed anyway. Because this is not the only thing that is up there for disciplinary action. Now, it can help him if he can somehow make this clear for the disciplinary action. But I don't think he is actually capable. I really don't. Because the rest of his filings are completely horse shit. So regardless of this specific issue, I think it's screwed anyway. But the state bar has asked for 6 months and a day of losing his license, which means he has to tell every client he has. He has to disclose it. And I do believe, maybe you can answer this, Dave, more clearly. He, in my opinion, he also has, if he's licensed in federal court and in another district, because this is Arizona, he is licensed in California as well, that he kind of has to inform the state bar in California and inform the federal courts that he has been sanctioned by the Arizona state bar. In my opinion. As you know, I don't practice law in the United States. I do hope to relocate to the United States eventually. And Randazza filed something too. In this case, hold on. Dun, dun, dun. I like Randazza. I really do. And apparently Mr. Randazza and Mr. Gingras are acquaintances. Dun, dun, dun. I don't see anything. Dun, dun, dun. So Mark Randazza is the secret attorney for Mr. Gingras. Now, Mr. Randazza is a really, really good lawyer. But I haven't seen in the filings that anybody, I don't see in the filings that anybody's representing David. He made the same arguments as Gingras. Well, his options are very, very limited. But I actually don't see. see. File on limited scope. Well, I can't find it. I can't find it. Now, if you have it, send it to me on X, through DM or through my email. That so I can take a look at it. And or I can just ask him. I can actually do that. Let's see here. He can lawfully be pro se in this, can't he? Yeah, I mean, yeah. In the state bar proceedings, he is acting for himself. I'm not sure how there can be a limited scope of representation. I'm not sure how that would function to be represented, have limited scope representation in a state bar case. I have to check in. I have to check. My gut feeling is that would be interesting if it happens. But if you have it, I gladly will take a look at it. But that would be for another day. It is almost 11 p.m. here. I am going to start cooking something because it's WrestleMania weekend. And I'm going to watch it. Yesterday was, today will be better. I'm sure of it. But folks, thank you. Thank you for allowing me to do this. Thank you for showing up on the Sunday afternoon where all of us should have better things to do. But this is quite fun. This is a fun case to follow. But again, tomorrow, Monday, me, Megan Fox, the Hernandez case. So check in tomorrow. Not sure when we will start, but sometime during the day. And the Hernandez case is another one of these state trying to kidnap a child, claiming abuse when the child had a medical condition. So that's for tomorrow and probably the rest of the week. If anything new happens in any of the other cases I follow, I will make a video on it. Until then, thank you again. From me and Mr. Gingras. You all have a good one. And I'll see you all in the next stream or video. Bye-bye.
Sail the raven waves, brothers, axes high, shields